Trey?
Yes, Your Honor.
All right, Trey, this is what I'm going to need because our system, could everyone please whisper? This is what I'm going to need because our IT is not working. So I'm not able to hear you from your location. If you could, your client can remain on Zoom, but are you able to call her and maybe you come into the court and we can do it by your cell phone if you do a conference call with her?
Sure, that works, Judge.
All right,
I'm right
thank you.
below you. I'll be right there.
And State, I'm assuming you're not going to have any objections to us doing it by conference call? All right, thank you.
Race fry. And he's got the pockets off that. On the back of that. Because.
Thank
Go ahead
you.
and get her on.
Yes.
Judge, want her to stay on the Zoom, could it be on the phone?
If they're not going to object, she can,
Just me.
yes. All right, are you ready?
I'm ready, Judge, and I've got her on speaker.
Thank you. All right, the court is calling 2023 CR 5888 State versus Anaya Gifford. Can I have parties announced for the record?
Megan Galloway for the state.
Trey Maurer standing in for Robert Maurer for Ms. Gifford.
And by phone, do we have Ms. Gifford?
Yes, ma'am.
All right, we're proceeding this way because the sound is not working on the court's end. Any objection to the defendant who was previously on Zoom appearing by phone?
No, Your Honor.
None from defense, Judge.
And Ms. Gifford, do you have any objection to appearing by phone? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Gifford, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it electronically?
Yes, ma'am.
Did you review the defendant's consent to plea by video conference? Any objection to the court adding cell phone?
No objection, Your Honor.
And none from defense, Judge.
All right, did you review the document entitled Defendant's Consent to Plea by Video Conference or Cell Phone with your attorney? Did you understand it and electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to enter a plea by video conference or cell phone. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
All right, off the record for a moment. Deputy Laura, could you all have them move to that other end? All right, we're back on the record. Sorry about that.
Sorry, Judge.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of service $2,500 to $30,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Gifford, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a citizen of the United States, by entering into this agreement, you can be deported, denied naturalization, and not allowed re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,000 fine. The state is opposed to your application for deferred adjudication or community supervision. There's a restitution of $12,000 to the complainant. Did you understand that to be the plea?
Yes, ma'am.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
There were not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offer states one in attachments.
No, no objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. State, you may be excused. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you going to be requesting a PSI?
We are, Your Honor.
All right, I need a date for PSI. Is there a need for a TAP evaluation?
I don't believe so, Your Honor.
Okay. All right, and Ms. Gifford, you'll need to appear in court on December 15th.
Please, ma'am.
All right, and probation. Oh, all right. Oh, Vashawn,
And I'm sorry, you said November.
15th. I'm sorry, December 15th. All right, so if she can come back onto the Zoom and I'll put her in a breakout room with Ms. Abrams.
Okay. Another, you hear that?
Yes, I'll go back on it.
Thank you.
You're welcome.
Maybe excuse Your Honor.
Yes.
Thank you very much. I appreciate you working.
Oh,
this
no,
out.
thank you so much for your patience.
It says PSI only.
Yes. I do not know why this is not popping up. All right, anyone else ready? No tap. Just PSI. All right, Claudel Carney.
Judge didn't bring them.
Like, why not?
They didn't make the cut.
All right, are you able to be back on Monday?
I'm in Carmel on Monday. Can we do Wednesday or Thursday of next week? No, Thursday.
We can do Thursday? All right. So we'll bring him,
May I have a couple minutes, because the witnesses are here to testify, kind of make sure that next Thursday works for them real quick.
well, let's do this. Are you able to stay here for a moment? All right, yes,
Your
they're
Honor,
gonna bring him.
if it's okay, then if that's the case, we would request an actual recess to Thursday, because I didn't know up until just a few minutes before walking to court, that one of my witnesses has to leave at 2:30. And if it's gonna take us a amount of time for them to bring them over, we request a full recess until.
How long is it gonna take to bring them here?
I don't know if you want to do tomorrow.
Hmm,
I was hoping that we could just get to that one witness that had issues on first, but if it's gonna take time to bring them over, she may have to leave before
who is the witness?
the victim's sister, who
All right, let's do this. See if you can have them appear by Zoom. And see if they have a phone on there where he can. Somebody over there can have him by phone or something. If that's possible. All right, so we will see.
If we are unable to start by 2:30, can we get a reset? Your Honor?
Yes.
Thank you.
All right, who else is ready?
Next one.
I'm ready to.
Page 10. Sorry. Page 9, Judge.
Mhm.
First one, regret. It's an empty.
Who do you have?
Cassandra, all this?
That's after Judge.
Oh, okay. Michael Rivera,
Judge, I'm further on that one.
where are they?
Same thing. We're going to the rescue.
All righty. They're gonna bring your client over. Have him brought over.
It's 7, Judge, for all this.
Cassandra Valdez. And Rivera can be brought over.
Judge, just for the court's information, we're going open to the floor.
All right. All right, the court is calling 2020-22 CR 5618, State versus Cassandra Luisa Valdez. Could I have parties announced?
And Richard Garcia for the defense.
And are you Cassandra Valdez?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cassandra Luisa Valdez who was placed on community supervision in 2022 CR 5618
Yes,
for
ma'am.
the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on March 7th, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 27th day of December 2023 in Bexar County, Texas. The defendant Cassandra Luisa Valdez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Guilty.
No, true or not true?
True.
Violated condition number 2, on or about the 24th day of January 2024 in Bexar County, Texas. The defendant Cassandra Luisa Valdez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Not
True or
true.
not true? I'm sorry.
Not true.
Violated condition number 4, in Bexar County, Texas. The defendant Cassandra Luisa Valdez did then and there fail to report to the supervision officer as directed for the months of February and March 2024 in violation of condition number 4.
How do you plead to that?
True.
State will waive the remaining.
Did you understand by pleading true to 2 and 4, the court could find it true, grant the motion, find, revoke and sentence you up to 5 years in the prison?
Yes.
Knowing that, do you still wish to plead true to 2 and 4?
I'm being honest. Yes, ma'am.
All right, the court will find 2 and
Amen.
4 true,
Yes.
and there's no agreement. Is that correct?
Judge, there is no agreement, but state would be recommending you grant state's motion to revoke and sentence to 5 years in prison.
Can I speak though?
Oh, just 1 second.
Okay.
Defense?
Your Honor, first of all, I apologize, I couldn't be here this morning. Cassandra's mother and daughter were here this morning and they wanted to testify, but they couldn't stay. They live out of town, and so they had to get back. And additionally, they were telling me that Cassandra has changed her whole life this last year. She's got a good job, and they were going to come ask for some leniency. In addition, Cassandra's asked me if she can address the court.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Cassandra Luisa Valdez.
All right. Is there anything you would like to say?
Yes, ma'am.
Yes.
Every time I have stood in front of you, sorry. Every time I have stood in front of you, I've been completely by myself. I've been dishonest. I've lied to you just to get out of here. Um, these last 2 years, I have completely changed my life due to the fact that my mom and my daughter have been back in my life. I didn't have them for the last 7 years because I was on meth. I was shooting up meth every single day. I would steal from them the first chance I got. My family completely turned their backs on me because I stole from them. These last 2 years, she just turned 21. She called me mom for the first time in 7 years. She used to call me by my first name. She has been back in my life. I've completely got off drugs. I am a manager at a car wash that I'm actually in the process of helping purchase, which is Cosmic. And he wrote a statement for me too, my manager. It's off of Fredericksburg and Hebner.
Have that statement.
Okay, I know. My mom was here. She was waiting. My mom hadn't been in my life in 7 years. She's completely back in my life now. And I feel like I have more to lose now. But back then I didn't even care.
All right, so here's the thing. What you're telling me, I have no corroborating evidence of that. I only have you saying it.
Okay, I can get all of that. I don't know. I didn't even know I had court, honestly. I wasn't prepared. I got told, I think yesterday.
Let me ask you this. Did you complete parenting classes?
I did. Yes, I did. I completed. Yes.
All right, probation, what has she done? Did she complete parenting classes?
Judge, don't have any indication that parents classes were complete. The only thing that I see completed is DDR.
She did 134 days in the BTRF.
Okay,
And that had parenting classes.
so here's the thing.
Yes, ma'am.
You've been on probation, and I'll allow anyone to ask questions.
Sorry, just, I forgot to mention that she did turn herself in.
Yeah,
All right, so any questions?
I was tired of running. I turned myself.
All right, so what I have before me is you've been on probation since March 7, 2023, and you really haven't done anything.
Yeah.
That's a problem. So I'm not going to continue you. So the court is finding 2 and 4 true. The court is going to revoke. The court, let me see. Was there any restitution in this case?
And
No,
it-
restitution to SAPP of $57, Judge.
Has that been paid?
No, Judge.
There's to be restitution to SAPD for drug testing. That's $57.
Okay.
There's to be no residing with minors and no unsupervised contact with minors. Court will give you credit for any time served and credit for any time served for any successful inpatient treatment. Court will recommend the therapeutic community. There's to be no contact with the following persons: Charles Young, Michael Villanueva, Sandy, and that's Sandy with the Y, Gonzalez with the Z. And the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you, okay?
Yeah, thank you for your
Thank
time.
you.
You're welcome. All right, and the person who's appearing by Zoom? No, I'm talking about the inmate.
I'm not sure how often they'll get them, because they're short.
Yeah, may we approach on this case, Sharon?
Just a moment.
Sure.
Sorry. All right, yes. Chris Ramos,
Well, I was just gonna ask, I guess,
we can recall it for tomorrow.
well, okay, can I go talk with the witness real quick about that, Sharon?
Mhm.
Thank you.
Put him on the docket for tomorrow, please. 9. I'm sorry, that's not for that one. It's, what is your client's name, please? Carney. Could I see Carney as well? Oh, this paper.
Odell Carney.
All right, so on Carney, we're recalling it for tomorrow
Well,
at 9 a.m.
Probably here.
All right, thank
Good
you.
one.
Tomorrow, what time is it?
9. All right, who's next? All right, is he here?
He's not present, Judge. It's off docket.
All right, so for me to set a bond, he'll need to be here, or either you can take it to Judge Nahara.
Okay, let me see if Judge Nahara's still in.
Okay.
Otherwise, I'll try and get him on the docket.
Okay,
Thank you, Judge.
you're welcome. Who's next?
Page 1, the bottom.
Okay. Yes. Yes. All right, Jerson Rios. But let them know Rivera is still to come, Norma. Yes. Rivera is still coming. All right, come forward, yes.
Hold on. Hang on, I'm just reading. The South Tower, it's not working, and we're trying to get into some of the doors. They're stuck.
So basically, whoever built South Tower just didn't do a great job because people want to go the cheap route.
They're stuck at South Tower too. They don't know how long it's gonna take before they open.
South Tower is on lockdown and they don't want to be on lockdown. Okay. Yeah, tell them to call us back in 30 minutes and let us know what the ETA. All right, so in this case, are you retained?
Yes, Judge.
All right, so this motion for the appointment of an investigator, you'll need to file that with an affidavit and we'll need to have a hearing on it.
The affidavit with Judge?
On the request for an investigator,
Correct.
if you're saying that he can't afford that, then you'll need to file an affidavit and we'll need to have a hearing.
Fine.
Okay,
I also have this motion, Judge, is to inspect the vehicle.
oh, I have this.
Oh, you
motion.
have that one. Okay,
Yes.
great.
State,
Yes.
all right, so they filed a motion, they want to inspect the vehicle.
Judge, so I reviewed it, and just so the court is aware, there is evidence that was retained from one vehicle or extracted from one vehicle, but the police department has told me that the other vehicle was unsupported for them to extract it. So I have no objection to his motion to be able to inspect. We've spoken and we'll confer and get a date together where we can both go out there and see the state of the property.
All right, so then with regards to your order on the motion to inspect, you all probably need to get together on a date and I'll sign it and you all can put the date in when you all are going to go out to inspect.
Okay.
Yes. All right, is there anything else?
That's it.
Okay,
Yeah.
your case was simple today.
No, yeah.
Yeah.
Yeah,
Oh.
and all you need now is from me, an affidavit from him that he cannot employ.
Yes, and we'll
Now-
need to have a hearing with that.
This, it's the vehicle of the deceased.
Okay.
That SAPD has not been able to extract any evidence from that vehicle. I have not yet employed crash engineers.
Mhm.
They tell me they can
Mhm.
and that they will, but they need an order from the court.
Okay.
And the reason why the family cannot afford this investigator is because the family is paying this expert $5,000
Okay,
to go get, and we're gonna share that with the state,
okay,
even though we're paying for it, so.
Okay.
One hand's gonna wash the other.
all right,
Thank you.
but who's gonna towel dry? I don't know.
Okay.
All right, so when do you want to come back on
I'll
your
bring the
motion?
affidavit tomorrow morning.
All right. All right, Deputy Laura and Norma, if you'll have him back tomorrow. And y'all need to be here exactly at 9 because I have mental health docket.
Thank you, Judge.
All right, thank you.
Judge, just one last thing. So as far, because this is a discovery setting, so I did, I believe discovery will be complete as soon as there's a phone dump that I have in my possession
Okay.
now that I intend to give to Mr. Barrera. It's just too big. So he's gonna have to bring me a drive and then I'm gonna get that to him.
Okay, all righty.
Thanks, Judge.
You're
We'll see you
welcome.
tomorrow morning.
All right, thank you.
Thank you.
You're welcome.
Okay, guys. Okay, yeah, that's perfect, that's all I need.
Will they supply a notary in the jail?
Usually, if you do it through the jail, the fact that they're in the jail, if you have the SID number, that would be considered. All right, that'll be considered legal. But you have to have something that shows that they're at the jail and you can bypass the notary.
Oh, bypass the notary.
Yes.
Okay.
All right. Irvin Ellison. Where's Mr. Leal?
He's on his way, Judge. He
And where's Donald Wilson?
He's not here.
No, I mean Donald Wilson, the attorney. All right, where's Dylan Smith? It shows that he's in custody. On page 7.
Virtual.
So call Mr. Wilson and let him know his client is not here and a warrant is going to be issued. All right, we'll take our
Did you add, I mean, I don't, did you ask it basketball? No, because Rafaela should be here already. Oh, yeah. He said he's gonna be here 30 minutes, no, over an hour.
Yeah.
Rivera?
Yes.
All right, the court is calling 2019 CR 5302 State versus Michael Armando Rivera. Can I have
Rivera.
parties announced for the record?
Very good. Lauren Espinoza for the state.
Anita Perez for the defense.
And are you Michael Rivera?
Yes.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Michael Armando Rivera who's placed on community supervision in 2019 CR 5302 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on December 3rd, 2019 for a term of 6 years? Is that you?
Yes.
All right, state.
Violated condition number 1, on or about the 5th day of September 2020 in Bexar County, Texas. The defendant, Michael Armando Rivera, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that, true or not true?
State will waive the remaining.
Any objections to the waiver?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 10 years in the prison? I'm sorry, yes?
Yes. Yes.
All right, knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Are you sure about what's going on here?
Yes.
All right, so you understand whatever agreement you have with the state, the court doesn't have to follow that agreement? All right, you're gonna need to speak up so the.
Yes.
All right, so do you understand if I find violation of condition number 1 true, that the court could sentence you up to 10 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
I don't know what you mean about that.
All right, so do you think you have an agreement with the state on what's going to happen with this motion to revoke?
Yes.
I don't have to follow that agreement. You don't have an agreement with the court. Do you understand?
Yes.
So I can sentence you up to 10 years just based upon your plea of true to violation of condition number 1. Do you understand?
Yes.
Knowing all of that, do you still wish to plead true to violation of condition number 1?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke and sentence to 10 years prison.
And is there this new number 1? What's happening with that?
That is my understanding that he was sentenced on that, and I believe defense has the specifics.
Okay, he's
Yeah.
been sentenced on that?
Right, I have I'll tender to the court and the clerks the judgment in the federal case. And I showed that to the state, and then this is the criminal complaint. And then I also have the docket summary from Pacer. And so if I can just put on the record the dates of incarceration. Judge.
But here's my question though. State, you don't have a possession of controlled substance that's been filed with your office?
No, Your Honor, that's based on the federal case.
All right, and you have no intention of filing?
No, Your Honor.
All right, yes.
Yeah, and so we're just asking, he's got, I think, 281 days in Bexar County Jail. And we're just asking for the court to acknowledge the dates that he was in federal prison. And from the documents that the court has before, it would be September the 5th, 2020, until he was booked to Bexar County, which is September 20th of 2025. And that, that's about 5 years, Judge. I think it's 5 years and 10 days, 14 days. So we're just asking for that credit as well, in addition to his Bexar County jail time.
All right.
And you want me to just hand it to the clerk?
Yes.
Okay. You want this?
All right. Are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court is going to grant the motion revoke, sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with the SA 20 MJ 1083. There is to be no residing and households with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. You can speak with the clerks to make sure they have the correct calculations.
And I don't know if my client wants to say anything, but, anything you want to tell him?
I be here 5 years ago with the other lady. Everything went good. I saw my 6 years paper. I know I did wrong. I lost a lot of my family, a lot of members. You know what I mean? I respect 187, you know what I mean? I like 187. But when I came the other day.
No. I mean, I guess with respect to
But
the
then
plea agreement,
with the
or,
plea agreement,
you know, I mean, as far as.
yeah, you did good. You know what I mean?
No, but as far as, I guess, just wanting to move on with your life
Yeah.
and get this case over with, obviously you've already.
That's what I'm telling you. Look,
Yeah.
I've been in the field for 5 years, and I lost a lot of my family, and I promise to you in here, I don't want to sell drugs no more. That's not for me. I did a lot of classes, rehab, and the facilities over there. I did RDAF, 500 hours. I did behavior. I did all that, and I think I'm gonna put this behind. You're not gonna see me no more over here.
Okay.
I promise.
Well, I'm hoping that's the case, because really with these charges, at some point in time, the police are going to catch you. And then you're going to end up either in prison, the state prison, or either the federal prison. And the federal prison, it's a lot of time when they
Yeah.
give it to you, but they give it to you in months. So you're just sitting there, oh, 60 months or 80 months doesn't sound that bad. And then you would do the calculations. You're like, whoa, wait a minute. So this is what I can tell you. If you have not truly changed, and if you don't get your life on track, it's not going to end well. So now and what I can tell you is when you're released from custody, it's going to be hard. You know why it's going to be hard? Because people are going to see your history and people are not going to want to give you a job. The best way to be employed is to have a trade or skill that somebody needs. And I was telling somebody before, I've had clients before who had major criminal history, and they're making major money legally. And you know how they did it? They went to trade school and they became a welder. Everybody needs a welder.
Let me tell you this real quick.
Mhm.
When I got this case, I know I make the bad decision to go to the Fed, but I chose somebody and then got me here and gave me this paper. But I mean, I'm not supposed to. I mean, you know, man, he told me to take the box, and I did. You know, man, I did my mistake. I did my time, and it's time to do this one and go home and do me. That's
All
all I
right.
was gonna say.
Well, just do better, okay?
Yeah.
All right. Good luck to you.
Thank you.
You're welcome.
Appreciate it.
You're welcome.
You got it? You got it?
Thank you, man.
Find it? Oh. 21, 23, that's like what? Six. No, it's 21, 23 divided by 365. It's almost 6. That's all we need to see here, because otherwise it's gonna be 4. You know? You only get me. Sorry to talk to both. Oh my God, you're not gonna let it down. I'm used to it, I'm a middle child. Oh, I did something.
Vashawn. because it's close to 5. All right, can I see this file, please? All right, if you come down. Hello.
Thank you.
All right, are you all proceeding?
On number 4 again?
Yeah, with the motion to revoke.
Yes, sir.
All right, do you have a,
For a contested hearing?
Asking if it can be reinstated.
We don't know that.
are you doing a trial court certification? I don't have a trial court certification of
Yes, ma'am.
defendant's rights to appeal.
Right to appeal, it's a plea bargain case, and you have the right to appeal, okay? This is not a plea bargain case. Okay,
It's just probation.
I'm sorry,
It's just probation we talking about. Huh?
well, you're on probation, but she can take it away if she deems that appropriate. But this is a certification that you have, this is not a plea bargain case, and you have a right to appeal.
What does that mean?
You want me to? Judge, I'm gonna have to set it for a contested hearing because, client is asking pertinent questions about it, and, may we recall it next week sometime or tomorrow?
No,
I need
it's
to
gonna
set,
be set at a contested hearing. Mr. Leal, we've been here since 9.
I understand, Judge.
All right, so here's the thing, Mr. Ellison, this is a contract with the court. It's not a contract with the state or with your attorney. So you can negotiate with the state, but it's not binding upon the court. So if you want a contested hearing, we will recall it back for a contested hearing, but it will be a contested hearing. The state will be bringing in witnesses to seek to prove up the violations that are in the motion to revoke. Do you understand?
No, I was just trying to see if I can get it continued. I was working. I was trying to.
Now, here's the thing. You're not at the phase where I'm to listen to what your reasons for why maybe the allegations in the motion are true or not true. Where we're at right now is I am explaining to you that you can't reach a binding agreement with the state and have it binding upon the court. So what that means is if you and the state come to an agreement, I don't have to follow it. Your range of punishment in this case, if I were to grant the motion to revoke, is up to 10 years in the prison. Do you understand?
Oh, I don't. 10 years.
Do you not understand or do you not want to understand?
I don't understand. 10 years for what?
You're on probation for a 3rd-degree felony. You understand you're on probation?
I missed the stipulation. I didn't call.
Yeah, that's what they're alleging, that you were unsuccessful and that you violated or did not complete certain things that they asked of you.
My first
So we can
violation.
either go forward now or either I can set it for a contested. Which would you prefer?
Was it contested?
Where they have to bring live witnesses to prove the allegations. That you did these allegations. That we went on.
Bring live witnesses to prove that I didn't meet stipulation.
All right, the court is calling 2025 CR 0034009 State versus Earl Ellison. Could I have parties announced for the record?
Galloway for the state.
Rafael Leal for Mr. Ellison.
And are you Mr. Ellison?
No,
All right, Mr. Ellison, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
yes, ma'am.
Did you understand it?
Yes, ma'am.
All right. Are you the same Irvin Earl Ellison who was placed on deferred adjudication in 2025 CR 0034009 for the offense of obstruction or retaliation on June 17th, 2025 for a period of 2 years? Is that you?
That's correct.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Irvin Earl Ellison did then and there fail to report to the supervision officer as directed for the months of July and August of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
You waive and abandon the remainders, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. State, what are you recommending?
We in the court to grant the state's motion and turn adjudication of guilt against the defendant, revoke him and sentence him to 5 years in prison, based upon the plea of truth, and we would take into consideration cause number 2025 PF 5850.
All right, in defense, what are you requesting?
Judge, I'm requesting that he be continue on probation, either defer or with a conviction. My client was homeless. He didn't have an address, was trying to get his life together. To his credit, he called the probation office, left a message telling the officer of his condition and what was going on. He was mainly focused on getting his life together, and perhaps did not appreciate that he needed to report on beginning with the intake, and he failed to do that. But when you don't have a home, a roof over your head, no money, going hungry for all the, once he was released, that's what clouded his judgment, in my opinion, Judge. And we're asking, when he was arrested, when he was just got a telephone and was in the process of calling the office to report. And we're asking that the judge, that the court continue his probation, and because I don't think the solution it is just to send him to prison. I think he should have that opportunity and perhaps take advantage of it.
So has he done anything?
He didn't have an opportunity to do that, Judge. He wasn't directed with an intake as to what to do or what to.
What do you mean he wasn't? So he wasn't told that he had to report?
I believe he was released, Judge, from either jail or from here when he took the plea, and to his credit, he called once, and
So you're saying he didn't know that he had to report?
that's not what I'm saying. I mean, I believe he was told, except that he didn't register.
So he's never reported?
Never reported, except by telephone. On
Uh,
one occasion.
Probation? Has he done anything? Has he ever reported?
Did initial intake in court with me. I don't have any indication that he reported after.
All right, so you're telling me that Miss Abrams never told him?
No, 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 that's not, he was told, when he was released as to what he needed to do, and he was probably even given a number to call, and he did call that number, except that he didn't follow up with that.
He was granted probation on June the 17th. On June the 18th, is, I guess, when he was released, there is a notation that that there was a voicemail from him. And after that, there was nothing else.
So you want to call your client as a witness?
Yes, Your Honor.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So I do swear.
All right, you can lower your hand, state your name for the record.
Reverend Earl Ellison Jr.
All right, you may proceed.
Mr. Ellison, when you were released, either June 17 of this year or June 18, were you given a number of the probation office and perhaps even a name of your probation officer to report to?
Yes, as soon as I was released, I used the phone in the lobby to make the phone call, and I left a voice message.
And what did your voice message contain?
I told him my name, and told him that I was checking in, and that was that.
Now, at that point, when you made that telephone call, did you have your own cell phone at the time?
No, I did not have my own cell phone. I actually just got it the day of the arrest, of the new arrest.
So you use somebody's telephone, either an office telephone or some other telephone?
I used the lobby payphone. Right before you walk out of the doors, when you get your cards, when you get your property.
Was that from the jail or from?
That is from the jail.
Okay. And what was your understanding? I mean, when you were given that telephone number, and were they your obligations? And were you informed of what your obligations were?
Well, I checked in. I knew that I would possibly have to try to make another phone call. However, I had no way of communicating or reaching out with anyone. So I would do small work, pick up trash and lots or whatever. I eventually earned myself a cell phone, and that's when I got arrested. And I was looking forward to actually making a phone call and continuing on with any said stipulation or whatever it may be. It wasn't.
So you were trying to work on a daily job or some other type of activity?
Yes, I was too.
Okay. And did you have a place of residence at the time?
At the time, no, I didn't.
Where were you living?
I was on the streets. If not, I would try to check in the Salvation Army.
Okay. And did you know when you were released that you were supposed to report in person to the probation office?
After release, no.
Okay. What would you like? I mean, what's going to be different if the judge were to continue you on probation? What's going to be different? How can you assure the court that you're going to be compliant with your obligations of community supervision or probation?
For now, if I get released, I'll be able to make phone calls and actually keep contact. That way I can have thorough communication. I can follow through upon any stipulation that is given for probation.
And that's what you wish the court to do, to reinstate you?
That is what I wish for the court to do, to reinstate.
And But the question is still gonna be, why didn't you do that the first time?
Trying. Out there trying to do better for myself.
Well, do you
Right.
understand that to do better for yourself includes following up on your obligations on your community supervision?
Yes, I do, and I do sincerely apologize for my mistake. It gave me another opportunity. I capitalized on it.
That's the way it is.
Okay,
Questions?
Mr. Ellison, so you were released from jail in around, like June of 2025, is that correct?
I'm not too sure. I'm thinking so.
It was earlier this year, right? Okay, and so when you took a plea on this case, correct?
Correct.
Okay, and you were placed on deferred adjudication, correct?
That's correct.
Okay, and the underlying facts of the case that you're here for today is because you told a police officer that you would fucking kill him. Do you recall that at the Chick-fil-A?
Probably said something different, but I do recall communicating with the police officer, two of them.
Okay, and so it's your testimony that when you were released from jail back in June of 2025, before you took off from jail, you made a phone call to probation. Is that correct?
That's correct.
Okay, but when you took a plea in this case, Ms. Abrams went over the conditions of probation with you, correct?
That's correct.
Okay, and she let you know that you could report in person or by telephone. Is that correct, to adult probation, right?
That's correct.
Okay, and so she also told you that you could reach out to probation in email form, right?
I'm not too sure. I was told that it was
In person or phone.
right.
Okay, and so the way that you ended up in court here today is because you went to Walmart in September of 2025, about a month ago, correct?
Correct.
Okay, and you were placed under arrest at that Walmart, correct?
Wendy's. That's correct.
Okay, that's how you're here today, right?
That's
Okay, and so when you were at that Walmart, it was alleged that you took a pair of headphones that cost $157 and didn't pay for those headphones. Isn't that right?
That's right.
Okay, and so my question to you is, how did you get to Walmart that day, but you cannot get to adult probation to comply with your conditions?
Walked.
You walked to Walmart.
Walked to Walmart.
Okay, and you acknowledge that you could have walked to adult probation to report, correct?
I don't even know where it's at.
So you weren't informed that it's across the street from the jail at 200 North Comal?
I don't remember that.
All right.
Just
And
trying to make
so,
the call.
I'm sorry?
I was just trying to make the call that way I can continue communication with.
All right. And so you didn't, you were arrested, and then that's how you ended up here today. And you stated that in between the time that you haven't reported, that you've been trying to do better. Is that your testimony to the court?
That's correct.
Okay, and by doing that, are you trying to do better by committing thefts of headphones?
No,
Would that be considered you trying to do better?
man.
You passed the witness.
No further questions.
All right. Is there anything else?
No, no.
All right. So, Mr. Ellison, I understand that when people are homeless, maybe they're not able to get from point A to point B, but you haven't done anything on probation other than pick up new charges. That's not good. And in this court, I always tell people communicate. And if there's an issue, we can try to solve that. But no one can help you solve your issues if you don't communicate with anyone. And one of I wouldn't say the worst thing, but being on probation and picking up new charges is not something good, because that shows that you can find the wherewithal to steal, but you can't find the wherewithal to get in contact with probation, which is across the street from the jail. All right, this is what the court is going to do. The court is finding violation of condition number 4 true. The court will take in consideration 2025 PF 35850, give you credit for any time served, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal, I'm sorry, the court is finding you guilty and revoking. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Like what just happened?
You have been revoked and you're going to go to the prison. And when I say go to the prison, they may end up paroling you from the jail. I don't know, because I don't know what credit you have in for time, or they may take you to the prison and process you there and parole you. But I've sentenced you to 4 years. Anytime that you've been in custody, you'll receive credit for that on this case. Legally, that is the law.
How much time?
I don't know how much time you have in. To the clerk, do you know how much time credit he has? I'm sorry, how many? 215 days. All right. Good luck to you.
Thank you, Judge.
You're welcome. And Mr. Lee, I think that may need to go to, I think you all get your copies, but then I think the state will have that,
Oh,
the original. But no, you have the copies.